maze of thoughts ensnare, every joke a blade prepared, cuts through lies with humor's flair, unseen wisdom few can bear. We're the one with biting charm, heart and brain a lethal arm. Stand unshaken, minds collide, laughing with the storm inside.
Heyo, folks! Heyo, folks! In the middle of this, my microphone disconnected, so I have no idea if you can hear me. So give me a thumbs up or something in the chat if you can hear me. And yep, loud and clear, loud and clear. Good, good, good. Welcome to the show. As you know, I have started covering the YNW Melly case, the retrial of YNW Melly. And yeah, it's a retrial because it was a hung jury last time. And last time you saw it with probably with another old white guy, with Jeff. And since he sadly passed, I'm going to do it. And Jules, who was Jeff's eyes and ears in the courtroom during the first trial, will be my eyes and ears in the courtroom once the trial starts in September. So, yeah, welcome here. And if you are new here, hi, I'm Nick. I have an actual law degree. I'm a jurist with over 30 years of law behind me. So, yeah, with all that in mind, today I'm going to go into some of the latest filings in this case. This is the petitioner's reply in support of Habeas corpus petition. They want YNW Melly out of jail on a Habeas corpus petition. Oh. Jack got his hearing moved from February to tomorrow. Okay, I'm going to cover that. Thank you, Factual. Yeah, if you're new here but thinks, he looks familiar. Yeah, I covered the YSL trial. One of few who covered that trial from day one to the final day. And I will cover the new trial and everything about it when it shows up. Thank you, Factual. I didn't know that. Then I have something to do tomorrow. Okay, let's get on with it. The petitioner's reply in support of Habeas corpus petition. Now, some spoilers. This is spicy. This is spicy. So, but, oh, for frick's sake. Oh yeah, before all that. This is the channel's motto, and it applies to this case. By far. I understand what you stood. Yeah, that trial was so long that Nick's hair was actually black when it started. Oh, that would come as a surprise for everybody involved, since I was more strawberry blonde thingy. And up until like 20 years ago when I started to turn gray. All right, let's get to it. Petitioner Jamal Demons, I don't know how you pronounce it, also known as YNW Melly, files his reply in support of his habeas corpus petition and states as follows. Introduction. Based on the Broward Sheriff's response, I haven't read it. I really don't care for it either because it's always BS. Always BS. Hey, Trakisha, good to see you. The record is now undisputed that in a death penalty case, Jamel Demons is not allowed to call any of his lawyers. Okay, apparently that was admitted to in the sheriff's reply. Further, Demons is not allowed to meet with his lawyers without barriers that prevent him from preparing for his trial. And Demons has been allowed no visitation or phone contact with anyone in the world, including his own mother, for Christmas or her birthday. Further, BSO does not care and has made it clear that this federal court has no right to tell it what to do. I should go back and find that response. The response of Broward Sheriff's Office, BSO, is shocking in its arrogance in admitting that it has engaged in conduct that can only be viewed as involving outrageous violations of the petitioner's rights under the 6th, 8th, and 14th Amendment to the United States Constitution. Despite the fact that the language and history of Section 2241 establishes petitioners' clear and sacred right to seek relief in federal court for prison officials' violations of his constitutional rights, BSO asks this court to turn a blind eye and essentially abdicate its responsibility to enforce federal constitutional limits on the arbitrary and capricious restrictions placed on the citizens' constitutional rights. Yeah, apparently, not being allowed to call your mother on her birthday because the sheriff thinks, nah. Oh. Yeah, that kind of hits home because for you who have been on my channel for long enough knows I lost my mother at a young age. And the contact between a child and the mother is essential. Same with child and father. Let's continue. Petitioner is asking this court to stop prison officials, including BSO lawyers, from violating his clear constitutional rights. He is not asking this court to stop his trial from going forward or interfere in how it is conducted. This court's relief would be directed at administrative officials, not judicial officials. So this is only towards the prosecution, only towards the sheriff's office. Why punish the mom is first best GG? Why punish the mom? Yeah, I don't know. We might find out. Starfish and Coffee says the state and sheriff's office are pissed that Bradley was recused and removed from the first trial. Yeah, I heard about that, and between now and the retrial, I will check out things from what happened in between, as in the misconduct hearings, because I've heard those were wild. Now I couldn't cover those because I covered the YSL trial. I can't do it all. I can't do it all. Let's see. Petitioner disputes BSO's factual assertions and justifications, requesting an expedited evidentiary hearing at which time petitioner will demonstrate his entitlement to relief. By its plain language, Section 2241 is the appropriate mechanism for a state inmate challenging the constitutionality of his conditions of custody. Clearly, petitioner is not appealing a state court judgment or state court order. Petitioner is not asking this court to stay or interfere with Florida court proceedings by staying or interfering in the proceedings. Finally, there are no requirements to further exhaust administrative remedies by the plain language of the 2241 when a petitioner is challenging non-judicial administrative decisions of jail officials, especially in this instance when BSO describes the futility of the administrative process. Finally, this court has the authority to order remedies to these constitutional violations short of release and without in any way interfering with his state trial. 2. BSO has admitted to actions clearly violating petitioner Demon's constitutional rights. BSO asserts that it has the right to violate petitioner Demon's rights to counsel by banning his lead attorney of record, Raven Liberty, and all his lawyers, if she is present, from visiting him without a barrier, in a case which the prosecution is seeking the death penalty. The disingenuous BSO response admits that the Corrections Department is engaging in the following acts and intends to continue to do so in this case if this court does not intervene. 1. Sorry. They have forced petitioner's attorneys to crowd into a boardroom without the ability to communicate in private with the petitioner. Oh, that's bad. Oh, that's bad. It's bad already at the first point here. 2. They have unilaterally decided to deprive his lead attorney, Raven Liberty, of her ability to even meet him in a setting where her conversations cannot be overheard by others, and where she can show him documents, review transcripts, listen to tapes with him, or engage in any meaningful dialogue. Now, this, in my opinion, if this is correct and turns out to be correct in the hearing, somebody needs to be fired. How do you prepare for any trial if you can't speak in private, attorney to client? Because if you can't, that is a violation of the attorney-client privilege. So more or less the sheriff's office is denying him a proper defense in this case, if this turns out to be correct. 3. They have extended this deprivation to any attorney representing him if Attorney Liberty is present, and will continue through the date of trial to deny Demons the right to prepare for his homicide trial, where he's facing the death penalty without the ability to review documents, listen to tapes, or review transcripts with his counsel of choice. BSO admits it has deprived Demons and will continue to deprive him through the date of his trial, with the right to call any of his lawyers, including undersigned counsel, ever. So denying him the right to call his lawyers. Demons, not demons. Okay. Thank you, Chloe Albert's Revenge. Demons. I'm not good at pronunciations. I really am not. 5. BSO cut off all phone contact with all of Demons' lawyers. 6. BSO has isolated Demons so he can have no interactions with other inmates or anyone in the outside world, has done this for 4 years and intends to continue doing so. Is he in isolation? Or restrictive what's the name of it? That's interesting. I wonder. Yeah. 7. BSO has prevented for years and will continue to prevent Demons from having phone contact or visitation by video or other means with his mother, his siblings, or anyone in the outside world, and will continue to do so through his trial. 8. Unlike other inmates who are alleged to have committed phone or visitor violations and have them modified for limited periods of 30 days, BSO has informed this court that they have the right to deprive demands of the ability to have phone privileges and visitors forever, even though he is presumed innocent. That whatever violation they claim, they can't do it indefinite. Hello, Mr. Jingles. Yeah, for you who are new here, here is the channel's actual owner, our fearless leader, Mr. Jingles, and we are all a part of the YSL Viking Thugs. Petitioner is asking the federal courts to do what is allowed by Section 2241 and take action to both remedy and prevent further violations of the petitioner's rights protected by the US Constitution. 3. BSO's response contains false and incomplete assertions that will be disputed at an evidentiary hearing. The petitioner intends to and will contest the factual assertions in the BSO response. A brief sample due to space limitations is as follows. Oh, here we go. 9 here. The response is filed for the improper purpose of the ongoing harassment and slander, if not only petitioner, but also specific members of his criminal defense team. 10. The response contains known fabrications of fact and previous statements made in open court. Oh, wow. 11. In 2022, a hearing was held before Broward Court Circuit Court Judge Andrew Siegel, wherein attorney Christian Tsubanus represented that, quote-unquote, Miss Liberty's video visit was banned because she set up several 10, 20 video visits using her confidential lawyer pin and gave that pin out to other people. This is what they claim is false. See Defendant's Exhibit 12, page 5. Yeah, we will get to that. We will get to that. BSO response. Quote, we have coupled with the information from a credible source that one of his attorneys was going to bring handcuff keys into the facility for an escape, which causes the sheriff great concern. Quote, end quote. But the credible source was an inmate named Myers. A prison snitch. Prison snitches is... Folks, prison snitches are bad. They have nothing to lose by snitching. Every time I see a trial where they produce prison snitches, it tells me the prosecution's case is weak. A prison snitch has everything to gain and nothing to lose by snitching, because if they are believed, they get time off, they get some stuff, or they can even, in the Zachariah Anderson's case, lying in court and be believed somehow, then go from risking life in prison to walking free. Let's get back to the thingy here. Inmate Myers, who was the same day put into a mental health holding cell and eventually moved out of the main jail due to mental instability. To date, inmate Myers has not been able to be contacted because his defense attorney is afraid of him, and he has orders in place that he must have a face mask on when brought to court or visiting with his attorney. Thus, BSO knows that the information that they presented to this court to justify their violations is not true and, in fact, ludicrous. Yeah, I would love an evidentiary hearing where the BSO is forced to produce this Mr. Myers. Oh yeah, I forgot about this. If you want to support this channel monetarily, but you don't want to support it with giving YouTube a cut, buy me a coffee. That is a way for you to support this channel, and the link to that is pinned on top of the chat. Let's get back to this. BSO response. Claims by petitioner to criminally tamper with witnesses for his pending capital homicide charges, but also to prevent petitioner from engaging in drug smuggling and other criminal activities with his fellow blood gang members. Oh God, yeah. Blood gang members. But no one ever alleged that Mr. Demo was a blood gang member until 2020, when a person named Danny Polo came on the case and all of a sudden he's falsely accused of being a gang member. But Mr. Demons does not have any gang tattoos and has never been initiated to a gang. His music and lyrics about gang association are made for First Amendment protected entertainment purposes. Are we going into lyrics in this trial as well? It's stupid. Stupid. And thank you, Gigi. Yes, this channel does not give legal, medical, or prison snitch advice. All opinions from the host, guest, and chat are for entertainment purposes only. Aren't you cuddly today, Mr. Jingles? What happened? Have you brought in rodents again into the house? Is this why you're so cuddly all of a sudden? Let's continue. Likewise, a recorded relay call on September 15th, 2022, between petitioner and his girlfriend spoke of Miss Liberty's conspiring with petitioner to smuggle in contraband photographs. But in the transcript attached to the defendant's response, Christian states, quote, "Those barrier visits prevent the introduction of contraband into the facility like personal photographs." If counsel will look at statute this, the definition of introduce contraband into a facility, the photo 15. However, this is not true. No search of DMO's cell has ever found any illegal drugs or weapons. Further, showing a client photos is not contraband as a matter of law. Florida statute this defines contraband as any written or recorded communication. This paragraph does not apply to any document or correspondence exchanged between a lawyer, paralegal, or other legal staff and an inmate at a detention facility if the document or correspondence is otherwise lawfully possessed and disseminated and relates to the legal representation of the inmate. And then you have any currency or coin, articles of food or clothing, tobacco products, cigarettes, cigar, intoxicating beverage, narcotic, firearm, blah, 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 blah. 16. Not only are photographs not contraband under the criminal statute, it is a legal impossibility that Christian comments were truthful because all attorneys have been behind glass. And other than Stuart Adelstein, all visits with any member of the defense team were behind glass. Sorry. 17. Petitioner is not permitted to meet the other attorneys he employs with no barrier as much as he wants in private professional visitor rooms, which, despite the BSO claims, this is not true. 18. The exhibits reference disciplinary reports that do not exist. It is untrue that the conditions imposed, namely a barrier visit with Miss Liberty, were done for legitimate security purposes. As already discussed, the glass barrier is only in place for attorney visits in which petitioner's defense team includes Miss Liberty. 19. Paragraph 80 is a fabrication. The response states, quote, on March 29th, 2024, another search was conducted in petitioner's housing unit. See incident report attached as Exhibit 18. Papers containing pictures and 2 kites were discovered in petitioner's cell. The exhibit referenced as quote-unquote 18 is a supplemental police report that details the shakedown of petitioner's cell, and the items confiscated were details as sheets of paper containing gang information. There is no mention of lewd photos, papers containing pictures, or kites. Quote, so based on the phone call that she, Miss Liberty, is smuggling into the facility photographs of girlfriend, the jail is continuing to ban her specifically from having contact visits with Mr. Demons. And based on the fact that she used Miss Liberty's name, the two male attorneys are now allowed in-person contact visits because that has dispelled that they are the subject of that introduction of contraband. Again, all searches of his cell have not yielded weapons or escape materials. BSO knows full well that the allegations that attorney Raven Liberty intended to smuggle handcuff keys is a totally discredited fabrication. They further know that likewise, the allegations that Demons has weapons or other contraband in his cell was a fabrication. But this did not deter BSO from presenting this information that they know has no credibility to this court. In sum, there is no justification for the ongoing constitutional violations. The handcuff key story, the gang story, and other slanderous allegations are not accurate. Further, the remedy for phone violations for other inmates have been brief suspensions and not permanent deprivation. This sound 4. This court has jurisdiction to hear this matter, and there is no procedural bar. Yeah, that's just procedures. More procedures. More procedures. The exhaustion of state remedies doctrine does not bar relief. Further state court relief is not available. Having been denied relief in the state courts when Circuit Judge Siegel declined to order constitutional access to a petitioner, there was no remaining effective state court review available at the time. The circuit court ruling was not appealable or reviewable as a matter of right, and trial court orders in criminal cases are not ripe for review until the entry of a final judgment, in which case the constitutional violations would continue through the outcome of the petitioner's death penalty trial and sentencing. Therefore, without any effective remedy to seek state court review of the unconstitutional administrative conditions of the petitioner's incarceration, federal court relief through paragraph 2241 is the only available remedy to cure the unconstitutional condition presented in this case. Which means Judge Siegel, who no longer presides over this case, made a ruling that was unreviewable and unappealable in state court. That is why they are taking this to federal court. The 11th Circuit has held explicitly that reversible error for a district court to dismiss or decline on jurisdictional grounds at this stage a Section 2241 Habeas corpus petition on grounds of failure to exhaust administrative remedies. Here's case law. As the unanimous 11th Circuit held, is that case in language applicable here? The Supreme Court's decision in Thaler and Reed Elsevier, both of which came after our Gonzalez decision, compelled the conclusion that Gonzalez was wrong. Congress has not stated that the 2241 exhaustion requirement shall count as jurisdictional. In fact, Congress said nothing at all in 2241 about exhaustion, which is a judge-made requirement. Section 2241 itself does not impose an exhaustion requirement, let alone that speaks in jurisdictional terms or refers in any way of the jurisdiction of the courts. There is nothing in the statute to support the conclusion that the judicially imposed exhaustion requirement is jurisdictional. It's not a lawful law. The district court also relied on one Supreme Court decision, Porter v. Nussel, but that reliance was misplaced. The Porter decision held that an inmate had to exhaust administrative remedies before bringing a 1983 lawsuit under the Prison Litigation Reform Act of 1995. It did not hold, however, that an inmate's failure to exhaust administrative remedies deprived courts of subject matter jurisdiction. And let's see here. More of this, more of this, more of this. And conclusion. For all these reasons, it is requested that this court hold an expedited evidentiary hearing and, at the conclusion, enter an order that will provide the appropriate judicial remedies to the ongoing constitutional violations. Respectfully submitted, Michael A. Beasy, Junior, Florida Bar, Certificate of Service. So yeah, this is really interesting, folks. Really, really interesting, because all this has been applied upon Mr. Demons since 2022, for more than 2 years. Sorry. And for 2 years, out of the 2,000, over 2,000 days, over 700 of them has he had these restrictions. He can't call his mom. He can't call her anybody. The defense attorneys has to schedule any visits, and then they will bring in. There's a glass barrier. There are people around who can listen in since 2022. And we are in 2025 now, folks, for over 2 years. And regardless on how you feel about Mr. Demon's guilt or innocence in the first trial, we don't treat people like this. He is, and until a jury comes back with a guilty verdict, he is presumed innocent. Presumed innocent. How is this not criminal? Because the prosecutors and judges has decided that they have prosecutorial and judicial immunity. That is not a law. That is a restriction they have came up for themselves. I'm not a fan. Not a fan. More or less, they are trying to break him, in my opinion. And this is not according to a Western due process, a Western way of conducting ourselves. This is more communist rule setting, communist due process, where, and I've been around for a while. I was an adult before the Berlin Wall fell. I remember those times. And folks, you don't want it. How good it feels. Oh, there are criminals. It's not a vacation. Yada, yada, yada. We are not a lynch mob, folks. We are supposed to be civil. We are supposed to abide by common rules, to respect the foundations of our judicial, our Western judicial society. Presumed innocent, due process rights, and everything in between. And it becomes apparent to me, the more I look into this case, is that the prosecution and the sheriff's office here are basically communist prison guards and communist prosecutors. Maybe not officially, but in their actions, they are conducting themselves as if they were East Berlin judiciary. I mean, he's been in jail since he was 19 and he's now 25 and deprived of company, regular folks, only prison guards and attorneys, and the occasional visit into court where he can see other people. So it's bad, folks. It's bad. What is good though in this case is that now when Judge Fien, don't know the pronunciation, seems to be a no BS kind of judge this far. So yeah, so no matter how you believe in Mr. Melly's guilty or innocence, that is beside the point in this case. You have to respect the rights against the government, because once you stop, once you get into being a government tool, there's no going back. If we allow the government to violate our rights and it becomes standard, it won't come back. You in the United States have something amazing in the Constitution and the Bill of Rights that exists nowhere else in the world. Nowhere else. And if this comes down to that prosecutorial misconduct and the misconduct from the sheriff's office, the fabrications and everything, if that means that Mr. Melly, Mr. Demon, is cut loose and is walking the streets again, that is not that is not something to be fixed in the judiciary. Oh, we need to make rights disappear so we can convict these people. No, this is on the prosecution, on the sheriff's office, on the investigators. It's on them if that happens, not the defense. It's solely the responsibility of the prosecution and the investigators. All right. That was really interesting. And I will go through more of these motions up. I mean, the trial is in September. We have 8 months to get there. So there will be, not maybe every day, maybe not even every week, but once in a while I will do one of these where we go through everything. So this will be interesting. And yeah, tomorrow apparently it is Jack got his hearing in the YSL trial. The only person in that trial that was acquitted on all counts is still in jail for bogus reasons. Corn Pope, yes, I heard that. I covered it earlier today in the stream. So yeah, I know Miss Liberty is being investigated. I also know that the prosecution tried to hide this from the defense. They have the prosecution has a week to produce the search warrant. And once they have that, oh, there can be hell coming loose. Ow! For fuck's sake. Mr. Jingles, do not boop with your claws out. Do not... Oh, you play so innocent now. When he's showing his belly, that's a trick. Because the moment I try to do a belly rub, he's going to attack me. Hmm. Yeah, so apparently tomorrow is a hearing for Jack Hardy. That will be interesting. And of course, since I've been covering everything else about the YSL trial, I will continue to do that from gavel to gavel. All right, that is what I had for you today. And I will continue to seek out information. Hopefully on Thursday, I will have Jules here to get me caught up. No, to get me up to speed, and maybe even another surprise guest. So tomorrow YSL, Thursday YNW. So yeah, thank you for being here, folks. Thank you for allowing me to do this. And let's just check here. Yeah. And folks, remember, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. See you tomorrow. Bye-bye.
Against the void, grasp the twisted threads of truth, laughing in the face of chaos, burning knowledge like a ruthless youth. Complex thoughts dance in the fire, cynics grin with a wisecrack's ire, fighting shadows with sharpened wits, baring teeth in a world unfit. We're the one with biting charm, heart and brain a lethal arm. Stand unshaken, minds collide, laughing with the storm inside. We're the one with biting charm, heart and brain a lethal arm. Stand unshaken, minds collide, laughing with the storm inside. Faces enemies with a jest, every laugh a cunning test, carving paths through blackened skies, inside clear and bloodshot eyes. In the maze of thoughts ensnare, every joke a blade prepared, cuts through lies with humor's flair, unseen wisdom few can bear. We're the one with biting charm, heart and brain a lethal arm. Stand unshaken, minds collide, laughing with the storm inside.